Good morning, everyone. Firstly, everyone at ECA would like to pass on our best wishes to the Prime Minister and also to all those affected by coronavirus. Today's webinar includes our regular expert, Andrew Eldred, ECA's Director of Employment and Skills, and also Andy Reakes, the Operations Director of the Joint Industry Board. Andy and Andrew will be discussing the latest on furloughing, alternatives to this, and related matters such as holidays, benefits and pay. After the presentation, Andy and Andrew will be taking questions, so please do post these in the chat box. All of ECA's guidance can be found at www.eca.co.uk/coronavirus, and you can follow us on social media at Twitter, LinkedIn, Facebook and YouTube. Over to you, Andrew.
Yes, thanks, Mike, and good morning, everybody. Yeah, it's that time of the week again. Yeah, we've had a succession of presentations as part of this webinar series, and they've so the last couple certainly have majored on employment, and that to a certain extent is reflecting the moving feast that is particularly the job retention scheme and furlough. And that feast has moved again, in that was new guidance issued a bit sort of under the radar on Saturday. We'll be going through some of that today. I mean, just as an overview, I mean, essentially what we've got in the new guidance is it's consolidated much of what we already knew. I think it's defined, redefined, reasserted what's covered and what's not by furlough. There are still some gaps, and the biggest gap really remains holidays, although you're going to hear from me and from Andy that we think that things are tending in a particular direction on holidays, which should give greater certainty. There are still some confusions as well, and there are one or two areas where, to be frank, the new guidance has, if anything, added to the confusion. But again, we'll try and give you a steer to sort of help navigate yourself through that. In terms of our own situation with ECA, my original plan when I spoke on Friday last was that we'd get our main guidance updated in time for Monday, principally to take account of a lot of the sort of questions that we've been asked, both through the Employee Relations Helpline, which is available to ECA members, but also through this webinar. That hasn't proved possible because I had assumed that we wouldn't be getting any immediate information from government. So what we did instead over the weekend is we drafted some information, some brief sort of information on what's new in the government guidance that was issued on Saturday, and that went live on our website on Monday. Also, what went live on the website on Monday was the bank holiday guidance. Bank holidays obviously looming, and I'll talk a little bit about that later. But both of those guidance notes, along with the existing main furlough guidance notes and other guidance notes covering employee relations, commercial matters, and so on, they're on the coronavirus web page of the ECA website, which is open to all. Turning today's presentation, yeah, I'm going to spiel for a bit, and then we're fortunate to have Andy from the JIB here. And clearly he's there, at least in part, to talk about some JIB specific things. Obviously not all ECA members are in the JIB, but it's an important section of our membership. So Andy will be talking about the interrelationship between furlough pay and the JIB employment package. He'll also say something about the Bupa benefits as they operate for people whilst they're on furlough. He's also going to talk about some more generic things that have an application to JIB and non-JIB firms to do with what the furlough guidance says about collective consultation and also on holidays more broadly. I'm going to preface that, though, with, as I said, a sort of high-level summary of some of the main new things to come out of the guidance on furlough that was published on Saturday. I'm going to deal with some hot topics. The hot topics, and you'll see them come up soon, are apprentices, the pay calculation. I'm going to revisit the pay calculation in the light of the new information that was published on Saturday. An issue which cropped up very much last week at last week's webinar, employers not able to afford to pay the 80% of earnings. Some more thoughts on that. and the issues I've already flagged of the upcoming bank holidays and how employers should be managing those, because obviously that's urgent. Then, of course, we'll have the Q&A at the end, which both Andy and I will participate in. Okay. Well, that slide really just summarises where we're at. As I've said already, 4th of April, the government uploaded its revised employer guide. There were some rumours that it was going to be uploaded on Friday, but that didn't happen. It happened on Saturday, and we provided our own guidance note summary on Monday morning. As you'll see, there is some clarification. There is also, in some areas, some modification of their stance. The calculation of pay, for example, is one area there. And I think after clarification and modification, it's fair to say there's been some continued obfuscation, particularly in the area of holiday and holiday pay. So getting to the meat of the guide, and as I said, I'm only going to cover a few sort of high-level things here. We do have the guidance on the website, and I do anyway, as we always do, suggest that you read all of the government guidance, just because we cannot cover everything either in our own summary guidance or here. If in doubt, of course, if you're an ECA member, then there's always the helpline to ring, and of course you can ask questions on the webinar now. So in terms of the things that I was going to highlight, new stuff or stuff that's sort of significantly changed, employers, if they're going to claim, will need to be enrolled on the PAYE online service. Now, I'm not an employer, I'm not a payroll specialist, so I don't know to what extent that's a given already. What apparently is the case is that in order to enroll, it can take up to 10 days. So if you are not enrolled at the moment, then you do need to get on with it, because that is going to be the mechanism through which claims, I suspect, are going to be submitted and payments are going to be handled. So that's something that's important. Paying for training, I put it in italics because I'm going to deal with that mostly in connection with apprentices. The thing to say here is that all that I think has happened in terms of the new guidance that's different from the old is there's been some clarification. In the old guidance, it seemed to suggest that if your employees did training whilst they were on furlough, there was an obligation perhaps, and it didn't seem to make much sense at the time, but the natural interpretation of the words suggested that you should pay for their time training at least the national living wage on top of what you're paying on furlough. I mean, that's now been clarified, and provided that people's furlough pay is at or above the relevant national living wage or national minimum wage level, then you don't have to worry about paying any extra for training. It's only if individuals are, with the 80% reduction, are on less, sorry, the 20% reduction, the 80% pay, if individuals are at that point below the national living wage, relevant national minimum wage benchmark, that's when you would have to top up. Carers, furlough for carers. The new guidance is kind of looking two ways, or seems to be looking two ways on this one. So we're going to try and provide some clarity, although the clarity isn't there necessarily in the guidance. I mean, the most important statement and the most valuable statement in the new guide is that those with caring responsibilities may be furloughed. So this is a category where there's an acknowledgement that in terms of the justification for furloughing, caring responsibilities in themselves provide that justification. What's less helpful is that the only example they give is those with caring responsibilities for children. I mean, that's useful in itself, of course. That's useful in itself, of course, because it for those people who have to stay at home to look after children who can't go to school, then that's them covered off. It doesn't address specifically the issue of people who are caring or looking after people who are off sick or self-isolating in relation to coronavirus. And of course, in previous guidance and legislation, in fact, people in that situation were defined as being entitled to statutory sick pay. I think, though, it's fair to assume that the breadth of the caring responsibilities wording in the guidance is intended to cover people with those caring responsibilities as well. So I think it's fair to assume that in those cases, those can be furloughed. We will, of course, be seeking clarification on that, but on balance, that seems to be a fair interpretation in our view. Shielding, though, is somewhat more problematic. And of course, this was a question for those of you who are involved in the previous webinar will know that this question was raised at the time by one of the participants. The wording that's used in the guidance is a little unfortunate. It says that people who are shielding and also people who are looking after people who are staying home with people who are shielding may be furloughed. They may be furloughed. In terms of those who are staying at home with people who may be furloughed, that they may be furloughed if they can't work from home. Actually, sorry, that's in relation to both people who are shielding and both people who are staying home with people who are shielding. In both cases, it says they can't work from home, so they may be furloughed. In addition, though, it says otherwise would need to be made redundant. Now, that's kind of importing for people who are shielding or staying at home with people who are shielding an additional requirement which doesn't apply for people, for example, who are defined as carers. That is confusing, that is unhelpful, and the government need to clarify it. I have to say, in looking at all the discussion of the provision with regard to people who are shielding, the general view is that the use of the words is misleading and probably unintentional. The words relating to otherwise need to be made redundant. So the general view is that the intention from Revenue and Custom is that people who are shielding or people who are staying at home with people who are shielding may be furloughed. But as I said, at the moment, the wording itself requires further clarification. In terms of company directors, the new guidance really restates the established position that company directors may be furloughed, but for furlough purposes, the pay calculation for grant purposes relates to their PAYE salary rather than any concession with regard to dividends. Now, there are campaigns going on at the moment to try and change that, but in terms of the guidance, in terms of the position being taken by HMRC and by the Treasury, it's very clear and it's uncompromising. What's new in the new guidance is that it increases some of the formal requirements, the formal sort of company requirements around any decision to furlough directors. The guidance says that such a decision should be, as a matter of sort of the formal proceedings of the company, it should be formally adopted, recorded, and communicated. So you can read specifically what's meant by that in the guidance itself, but it is adding, if you like, to the formal Companies Act aspects of this. Also, with regard to the sort of interaction between the Companies Act and, if you like, employment, it does talk in general terms about directors being entitled to continue their Companies Act duties as directors, but does draw a very clear line between Companies Act duties and doing work for the benefit of the company. So it does talk in terms of the Companies Act duties do not entitle a director to generate revenue or provide services for or on behalf of the company. I mean, that raises some interesting questions, which we're going to give some more thought to in terms of the interaction between furlough and the director's duty to promote the success of the company, which is one of the duties that exists under the 2006 Companies Act. But they do seem to be taking a pretty hard line and trying to minimize that. So I think probably the practical advice for any employer in these circumstances, directors in particular, is to be very circumspect about the work that they do if they go onto furlough. Consulting and recording worker agreement. Andy's going to talk a bit more about consultation. In terms of recording worker agreement, just to say that the new guidance is much more definitive in saying, A, that any agreement with your employees or workers to go on furlough must be in writing. And you'll be aware, of course, that for some time, the ECA guidance that's part of our furlough guide has got a template letter which employers can use. But it also adds that agreement needs to stay on the record for 5 years. I'm not entirely sure at the moment what the significance of 5 years is. I guess it probably has a significance in HM Revenue and Customs world. It doesn't have much significance in an employment world, but in an HM Revenue and Customs world, conceivably it does have some significance. Finally, on calculating salary and average pay, I'll come to that in detail in a sec. Finally, for this slide, switching between furlough and work. You'll be aware from the webinars, from the guidance, from all the discussion that's been going on, it's been a big issue as to whether employers can rotate employees between furlough and work, particularly if you're rotating different groups of employees between the two. It's fair to say the guidance does not say in terms that you can rotate in that way, but it gets pretty damn close to it. And certainly definitively says that you can switch furlough on and off again for people and then on again. So that clearly envisages the possibility of people moving from furlough to work and back again, and certainly doesn't discount, whilst one group of people are on furlough, the other group of people being on work and then them swapping around. The principal condition, though, is that any period of furlough still must be a minimum of 3 weeks. So clearly one pattern, if you were simply going to divide your workforce in two, would be three weeks on, 3 weeks off. Other arrangements, though, are possible. You could have an arrangement where it's one week of working, 3 weeks of furlough, and a range of different things in between. So there is the flexibility there. The other area, though, where there have been concerns, and these have been repeatedly expressed to government, about the difficulty of accommodating furlough where employees are required just to do a limited range of work, so the critical business, emergency cover, and so on. Of course, that's a big issue for many of the contractors in our industry. The government have yet again definitively said that furlough is incompatible with somebody working reduced hours. What they do suggest in those circumstances is to use people who are working to cover in some way for that work, and that potentially envisages, a limited number of people covering off under some kind of potentially rotational arrangement. But certainly for the time being, the indication seems to be that the argument about including reduced hours arrangements within furlough, as far as the Treasury is concerned, apart from as far as HM Revenue and Customs are concerned, that debate is now closed. Okay, moving on to the next slide, to my hot topics. Apprentices. Obviously, a lot of ECA members and other employers in the industry have apprentices. And the guidance is definitive now. As of the 4th of April, it explicitly says, yes, apprentices can be furloughed. I think there were some question marks about whether that was the case. And there's also a recognition, given that face-to-face training and assessment activities are suspended, given the fact that employees more generally have been furloughed, there is a recognition from all that is a likelihood, at least in some cases. There are additional issues, of course, when it comes to apprentices, and I think those additional issues to do with the relationship with apprenticeship funding, to do with the relationship with the training provider, those I think were some of the additional issues that led to some hesitation to be definitive that apprentices could be furloughed. But that has largely now been cleared up, in that you've got guidance now from the Education and Skills Funding Agency in England and parallel guidance in Wales from the Welsh Government, effectively acknowledging that furlough is a possibility. and relaxing the restrictions on breaks in learning in those circumstances. Breaks in learning, particularly longer breaks in learning, have historically been quite constrained, and a break in learning has largely been a matter for the apprentice. As a concession in the current environment, it is now possible for an employer or a training provider to initiate a break in learning. You'll see also in the ESFA and Welsh guidance, and we will provide links to those in the furlough guide when it's updated. But they emphasise the importance of college and training providers trying to keep training and development going on. So all of those colleges and training providers, to the extent that they are able to, and of course some might not have the resources or the wherewithal to do so, but to the extent that they are able to, they are being encouraged to provide online training provision and tutor and assessor contact online to apprentices. The issue that I've already mentioned in relation to training more generally arguably does have a greater resonance when it comes to apprentices, which is the issue of pay. If you have apprentices who are training whilst on furlough, then there is potentially a requirement to top up their earnings to the relevant national minimum wage, national living wage level. And of course, remember, there are apprentice rates under the national minimum wage. But there is a requirement to top up if the furlough payment you're making is sinking below that benchmark of 100% minimum wage, living wage minimum. Probably less of an issue for apprentices later on, unless you're simply paying your apprentices the national minimum wage, national living wage. Less likely to be an issue, therefore, if you pay your apprentices JIB apprentice rates rather than sticking to the national sort of legal minimum. I'm not sure in terms of the early stages of the JIB apprenticeship whether that's Andy's probably the best guy to ask in terms of the level of detail. I think the most important thing for you, though, is you need to talk to your college, you need to talk to your apprentice, you need to talk to your training provider and discuss how this is going to be managed over the next few weeks, if you haven't already done so. They should have been in contact with you, your college or a training provider. If they haven't been in contact, get in contact, have the conversation, and certainly you'll need to discuss the view that you're going to take in terms of any training whilst your apprentices are on furlough, because it does have pay implications potentially. Just to flag up, in terms of JTL, those of you who use JTL, you probably would have heard from JTL. JTL have got online training provision and are putting more and more online training modules onto the system. And they are saying that online contact between apprentices and their tutor or assessor will be fully available after Easter, provided that the apprentice is attached to a JTL training centre rather than just the local college. Hot topic 2. Okay, this is really the question: what has changed? What's the same in relation to the new guidance that came out on the 4th of April to what we said before? Well, the good news is the basic approach has not changed, and it hasn't changed really from our interpretation of it. Specifically, those of you who've been on previous webinars will recall there was a question of is the 80%, the 2,500 benchmark, is that based on simply basic hours, or would you take account of overtime? We concluded that the way that the wording was that overtime was included, and the 4th of April amendments reconfirm that. So you still have a system whereby salaried workers, the calculation is one way, really based on the salary. Workers whose pay varies is based on an averaging, depending on how long they have been employed by you. In terms of some of the additional detail included in the guide that was published on the 4th of April, that does mark a little bit of a change. There has been some modification there. I mean, previously, you'll recall the guidance said that no bonus or fees or commission were to be included in the calculation of pay for the purposes of the grant. That has now changed, and you'll see the detail on the slide, but essentially what's happened is that the Revenue and Customs are now differentiating between what they call obligatory payments and discretionary payments. So if something is paid and it's an obligation to pay it, for example, if an employee works overtime, there is an obligation to pay for that overtime, then that would be included, provided that the overtime is regular. Discretionary payments, such as a discretionary bonus, that is excluded. So obligatory as opposed to discretionary payments is one area of distinction. The other distinction is really between monetary payments and benefits in kind. A great deal more clarity that really benefits in kind are excluded. And I notice that one specific exclusion picks up on one of the questions we got at the last webinar, which is what about salary sacrifice schemes? In those circumstances, the furlough grant would be based on the payment that's actually received by the employee, no sort of grossing up to take account of the money that's been sacrificed and has gone in to the pension, or any other kind of salary sacrifice scheme. Okay, now this is something which I know a number of employers raised in our last webinar. And it's something which, I mean, in many ways, we were fortunate to have some very different sort of expert insight from Liz Bridge at the time. And so what it was companies either on their own behalf or on behalf of others that they're aware of saying, what if a company can't afford to pay the 80%? Now, I guess the initial government response would be on that, well, we've got all these great loans and so on and so forth. But of course, experience has proven that those loans are more difficult to obtain and more onerous to obtain than maybe the speeches and the media releases lead one to believe. So what seems to be happening, based on the information that's been shared with us, is that some employers have reached an agreement with their employees to pay less. And in some cases, that's been on the basis of a promise or a hope that they will obtain the full grant, the 80% grant from the HMRC, and then be able to increase wages and even reimburse people, effectively sort of a back pay kind of arrangement. It's fair to say that in the guidance, it's not really envisaging that situation. I mean, Liz Bridge, who clearly as a tax specialist is someone who is familiar with how HMRC think and how they work. I mean, her insights, for those of you who didn't hear them last week, I think were important. I mean, her first insight, based on coming to the guidance with a cold eye, was that what the guidance was about was not directing businesses as to what they should be paying people who are furloughed, but simply defining the grant, or the maximum grant, that the government would be prepared to pay. So that was an interesting insight in the first instance, because it's not something, it's not the way in which it's been framed elsewhere. It followed on from that, and this was Liz's second insight. If you agree with your workforce that they should receive less than this, from a policy point of view, she could not see why HM Revenue and Customs would not then decide to reimburse at least what you've paid. She was, though, skeptical about HMRC reimbursing something that you haven't paid, based on their general approach to grants. So if you've paid nothing, she didn't think you'd get anything. And if you've paid just 50% or 30% or 60%, she believed that you would be reimbursed against what you'd actually paid, rather than that being topped up. Now, the answer is that we don't know what the answer is on this. It's fair to say that reading through the guidance, you can see language that indicates that the 80% is mandatory. Employers shall, in order to qualify this for the scheme, employers shall. On the other hand, there are other elements of the guidance which seem to envisage employers receiving a grant from the revenue and then paying it on. Clearly, we need further clarification on this. Thinking it over, I suspect what Liz has described might very well be what happens in practice. In other words, that the Revenue and Customs will reimburse based on what's been paid. From a policy point of view, of course, the main incentive is to try to support employment. So in the event of supporting employment, albeit below the 80%, the objective to support employment would seem to trump it. On the other hand, and I think this might be the source of the frustration and the source of the lack of clarity, there is also a strong policy argument for government not to say that. For government not to say that employers can pay less than the 80%. I mean, further comments to make is this issue is practically invisible in terms of what you see discussed around it, and it's probably reflecting the degree to which the debate, the discussion is dominated by the concerns of large and relatively well-resourced organisations. We have raised it through the Construction Leadership Council, and we will continue to raise it. Options in the interim, well, they're set out there, and I don't think there's anything there that you will find surprising, or I must confess that you'll find particularly helpful if you're in this situation. Go ahead, pay the 80%, get a loan. Are the loan terms now more favourable? You're probably in a better position than I am to judge on that. Pay less, but hope that the Revenue and Customs will at least reimburse what you've actually paid. As I said, from a policy point of view, you could envisage that happening, but we don't know for sure that it would happen. What I would say is if you do end up agreeing with your employees to pay less, you really, really, really must have that as a written agreement in writing. The new guidance published on the 4th of April is even hotter on the importance of written agreement than the previous guidance. So that is something that absolutely you must have, and it's highly likely that the Revenue will want to look at that. In terms of whether Revenue and Customs will reimburse more than you paid, effectively allowing you to share back pay with your employees, as I said, Liz Bridge and others who are familiar with the way that the government works when it comes to grants and how they reimburse have expressed scepticism about whether the Revenue and Customs would reimburse in the event that there hasn't been payment. However, as I've said, we can only do what we can do, which is continue to raise the question and emphasise how important it is. In terms of redundancy, that is potentially an option, although you will come up against, of course, the argument that the existence of the scheme, at least in theory, means that redundancy isn't necessary. If you do feel at any stage that a redundancy is your main option, your only option, as an ECA member, I would strongly advise you to take advice from the Employee Relations helpline, because it is a very difficult area to navigate. Final hot topic. Is that going to come through? It's not coming through with me. It's come through now. Okay. Fortunately, I think this area is an area where, despite the guidance not being clear, in fact, it doesn't really address the issue at all, I think there is a general sense now of what the right answer is. Andy's going to talk to you a little bit later in terms of holidays more generally. But in terms of the issue of public holidays, bank holidays, and of course we've got 4 bank holidays coming up over the next couple of months, they're still happening. They are still happening, And if you, as an employer, already have, either in your individual terms and conditions or in a collective agreement like the JIB, and the JIB does have this provision in, if in those contracts or collective agreements you have a provision where public holidays, bank holidays are part of the holiday entitlement, then they continue to be part of the holiday entitlement. If they're not, then you would need as an employer to communicate, notify employees that you want them to take the public holiday and or get their agreement. Notification, you need 2 weeks. It's probably a bit late for Good Friday and Easter Monday to do that. But I think in most cases, people have these public holidays, these bank holidays, as part of the overall holiday entitlement. The more contentious issue, although I think it's becoming less and less contentious now, is what the relevant holiday pay calculation is. There is a view that people on furlough should simply get the furlough pay, the 80% on holiday, because that is their normal pay in their current situation. That is not, though, the overarching view, and if you've seen the holiday pay guidance, the bank holiday pay guidance that we put out yesterday, you'll see it's not our view either. And more importantly, it's not the view of ACAS. Now, we haven't had official guidance from government as yet, but we do have effectively semi-official guidance, which is ACAS. ACAS is a non-departmental public body. Its members are appointed by the government, by the Secretary of State. And so what it says does carry some weight, although it's not officially the government. ACAS have recently updated their guidance. They have confirmed that employees should take the bank holiday as normal. They have also confirmed that for the bank holiday, the pay calculation is the usual holiday pay calculation, not purely based on the furlough calculation. So for holiday pay, it's conventional holiday pay calculation based on average earnings. Important thing to note, from the 6th of April, the reference period for calculating average earnings is now 52 weeks rather than 12 weeks. And another thing to note, which isn't on the slide, but it is something to bear in mind, that when calculating average earnings under the Employment Rights Act, weeks in which the employee does not work are excluded. Our view is that a furlough week, by definition, is a week where an employee doesn't work. So when calculating your average pay, you need to disregard the furlough weeks and go back a further week to really those periods when the employee has been working. Final slide from me before I hand over to Andy. Just to make you aware that we are aware that furlough isn't the only game in town, although sometimes it can seem like it. Businesses are still doing their best to operate, and so there are still people working. We issued last week an updated guide entitled Alternatives to Furlough, which is really attempting to give you some options to try and help balance your workforce off. One area not included on that list at the moment, but I think we'll have to include from now onwards, and an important one, is probably the rotational aspect of furlough. So rotational patterns around people on furlough, off furlough, on furlough again. So I think that's probably something that we'll look to update in due course. So just to wrap up from me for the time being, we do have some interim guidance which summarises the latest government guidance as I've described to you today. It goes into a little bit more detail than I've been able to manage so far today. We've got a specific guidance on bank holidays, which I've summarised to you now, and we are expecting to have the main furlough guidance, which attempts to pull all of this stuff together, including some of the other sort of frequently asked questions that we get in this area. We're hoping to get that loaded onto the coronavirus webpage on the ECA website, available to all by Thursday. I'm going to hand over to Andy now, and then of course we're going to have questions.
Thanks very much, Andrew. Good morning, everyone. Firstly, I want to say thanks to the ECA for having me on today, and for the introduction. So what I'm going to cover here is a little bit on the JIB collective agreement, how that interplays with the job retention scheme, with furlough, and then also some other elements that come off that. So holidays was mentioned, also the benefit scheme, so healthcare provisions that apply under the agreement, but also an idea around collective consultation, which I believe is one that's been mentioned in this webinar series previously, and how that again relates to furlough. Just to make you aware, many of you may have seen this, and I know Andrew has covered this in previous webinars. The parties to the JRB, so ECA and United, agreed a temporary relaxation to the normal terms of the JRB agreement. And this is around the guarantee week, 37.5 hours. So that was agreed as of 24th of March. And that means that employers and employees are free to make alternative arrangements in order to access the job retention scheme. That was a temporary relaxation for a 12-week period. So it runs through to about 12th of June, and will cover the current life of the job retention scheme, which runs through to the end of May. Now, I'll come back to that in a little while, whether that indeed will be the finite end date, but at the moment, job retention scheme runs to the end of May, and companies and employees can make alternative arrangements until after that, till the middle of June. I will say that relaxation, that temporary agreement is being reviewed. The parties will be having discussions about how that can be best utilised. But as part of that news item that came out, we are advising that employers begin discussions with their employees in good time, and really give as much notice as possible if looking to use the job retention scheme and put employees onto furlough. Now, as many of you will be aware, under the JIB agreement, there are a number of different payments, a number of different national working rules that makes up somebody's regular wage. And there are, thanks to the updated guidance over the weekend, we've now got a clearer picture of what can be claimed in that 80% of the employee's wages. So what the guidance refers to as a regular wage or regular payments that can be claimed, that 80% will include things under the JRB agreement like the London rate. Specifically, overtime has now been mentioned. I'm sure that will be relevant to the vast majority of companies and their employees, and will mean that many more will now hit that cap of £2,500 per month than would have done on a previously on an 80% calculation of the basic wage. So the overtime is now included. Also, under JRB agreement, there's provision for elements like responsibility money. So these are approved electricians who are undertaking supervisory responsibilities. That might be up to an extra £1 an hour on the rate. Where that's being paid, where that's been a regular feature, that could also be included in that calculation. Likewise, project uplifts as contractual payments can be included. So this would be NICI project agreements, for example, other specific site increases that apply. Something like Heathrow under the HAL agreement, perhaps. Also, productivity and incentive schemes. There's provision for that under the collective agreement. If these are in place, then that could also form part of that regular wage. It's a contractual benefit, so it can be claimed. I would just make sure on that point that it is, it's not a discretionary payment, that it is a contractual payment. So the elements that would not be included, discretionary bonus payments. Had an example this morning, actually, speaking to a member that they paid a Christmas bonus. Said, would they need to look at using that calculation? But it was something that was purely discretionary. So no, that would not be included. Likewise, expenses. So under the JRB agreement, that would include things like lodging allowance and also mileage allowance. The other element that Andrew mentioned earlier, benefits in kind and non-monetary payments, so things like the benefit credits, they would not be included when making that 80% claim for wages. Now, I mentioned collective consultation, and I know some questions came up in the past about varying terms and conditions, particularly under the JRB agreement, but there is quite an important point in here that will apply generally. So, under the Trade Union Labour Relations Consolidation Act, TULCRA, this covers situations for collective consultation arrangements around redundancy. And the legislation defines redundancy as dismissals for reasons not related to the individual. Now, in a normal employment context, so for non-JRB members, that could include things like proposed variations, proposed changes to terms and conditions, where the employer may look to dismiss and re-engage. So there's an employment provision that may allow that, and that's where the HMRC guidance has come in. So under that guidance, it talks about that it may be a requirement for consultation. It says it may be necessary to engage in collective consultation to procure agreement to terms and conditions. And really taken from law, it's around this situation where companies are potentially considering a dismissal and re-engagement. So the normal consultation requirements apply as they would do for redundancy. Now, that's starting consultation as early as possible, but no later than 45 days before the first dismissal if a company is proposing to make 100 or more employees redundant or to dismiss for these purposes, or 30 days before if it's between 20 and 99 affected employees, and that's anyone within a 90-day period. Now, the reason that this may potentially apply to all contractors is what happens following the end of the job retention scheme. So when the government scheme ends, currently that's the end of May. If that is not extended, and I don't think there is any reason to suspect at the moment that it would be, then it means that larger employers who would potentially be considering redundancies for, say, 100 or more employees would need to begin consultation 45 days before. So a quick bit of maths this morning, that puts it to Thursday the 16th of April, so that's next week. And I know the CBI have been lobbying government for an announcement as to whether there would be any extension to the job retention scheme by next Thursday for that reason. So this is something that will only affect those larger members that may be in a position where they have to consider those redundancies. I know Andrew's already mentioned there is support from the employee relations team. JRB member companies as well are welcome to speak to the industrial relations team at the JIB, but we will only be able to give information on the agreement as it sits now. So it's just something to consider, particularly for those larger companies. The idea, though, around HMRC stating that collective consultation may be required, this is something which has been discussed and negotiated by Unite the Union and the ECA under the JIB agreement. So as long as employers are following the required process, using template letters, I know the ECA have a template, JRB also have a template letter specific for those operating under the agreement, using that process, following the necessary guidance, then there should be no need for collective consultation where there is, in effect, a variation to use the scheme. That has been done, and that's part of the benefits of operating under a collective agreement. The last bullet there, just around variations. So it's just worth noting that the temporary arrangements have been to relax National Working Rule 3, that 37.5-hour week, but other provisions under the agreement still apply. It's not to say that that may not change in the future, but if that were to do so, that would need to be done by the parties, so ECA and Unite. And again, any members would be kept informed of any potential changes as and when they come up. Now, in regards to holiday and furlough, when I started to think about this last week, I did expect to see some further guidance around leave from HMRC or through the government over the weekend, and indeed we got an update on Saturday, but notably absent in all of that guidance was any mention of holiday. So we're still very much in the same position as we were previously, although, as Andrew mentioned, ACAS and other organisations have seemed to shift, and there is now more of a consensus. So 2 main issues with holiday. Firstly, can employees be required to take leave during furlough, or indeed choose to take leave? There appears to be no reason to suspect that's not possible. As was mentioned, legal opinion is still somewhat divided. However, we have seen ACAS now take far more clear view on holidays, and they have said that if an employee is furloughed, temporarily sent home because there is no work, then they can still request and they can still take holidays in the usual way, and that includes bank holidays. And by extension, there has been no change to the working time regulations. So that should mean that employers can still require their employees to take annual leave as long as they give the required notice. When looking at how leave is calculated during furlough, again, our position is the same as the ECA, same as many others, and this appears to be less of a contentious issue now. The law hasn't changed around how to calculate holidays, apart from this week, the new average period used is now 52 weeks rather than 12 weeks, but it's still a normal earnings level. It's calculating leave in the same way as you were previously. And under the JRB agreement for bank holidays, particularly given that we've got the Easter weekend coming up and indeed 2 further bank holidays in May, all of those are calculated in the same way. So a normal earnings level, that's an average over the previous 52 weeks. And again, as Andrew mentioned, not including any weeks where work has not taken place. So that would be complete weeks of sickness or indeed furlough. The other recent change that we have seen, this was Friday before last, that there was an amendment to the working time regulations via the Coronavirus Amendment regulations that has now allowed greater flexibility for the carryover of leave. So now this can be carried over for 2 years, but it is an option. It's not a requirement. And really, the press coverage seems to imply that this was mainly for people in, say, the NHS or healthcare services that would not be physically able to take leave for the foreseeable future. It may be something that they need to carry out. So there is just greater flexibility there. Now, I mentioned the benefit scheme under the JRB agreement. So these are terms and conditions that relate to private medical insurance, sickness with pay benefits, life insurance, disability benefits, etc. There has been some updates from ECIS in the last week or so. ECIS, the insurance services company, many of you will be familiar with. They administer the benefit scheme on behalf of JRB members. Firstly, Babylon is a digital GB service which is live and available to members. It's something that will give faster access and is utilised via an app. There is also within that an AI-driven symptom checker. So that will cover a full range of conditions, but has been updated to include COVID-19. All companies that are under the benefit scheme should have been contacted already with an update of how to use Babylon, how to download that for your employees. But there's also a user guide on the ECIS Canopy system. So if you log on to the ECIS website, under the forms and guide, there's information on there, including code that will be necessary to use the app. So I would advise any companies under the agreement to have a look at that. Also, there is the Bupa Employee Assistance Program that's still in place. It's completely free and operates 24 hours a day, 7 days a week. And that will cover a number of issues, so including stress, anxiety, depression, financial concerns. And then this is realizing that this situation, and particularly furlough, and particularly for those that may be in a redundancy situation, it's going to have an adverse effect on mental well-being. So as will indeed anyone in self-isolation, anyone that's isolated, detached from friends, family. So that service is available, and I would recommend passing that information on to anyone that wishes to use that. Also, under the scheme, Bupa have recently clarified that the cash benefit for NHS overnight treatments does apply to COVID-19 cases. So that's £200 a night, which can be reclaimed. Again, if that's relevant to any of your employees, anyone under that scheme, please do contact ECIS, and they'll be happy to run through how that's managed and also some of the other benefits.
Thanks, Andy. We'll move on to the Q&A if you're ready to do so, Andy.
Yeah, absolutely.
Perfect, thanks. So the first one's from Neil Kavanagh. The wording in the HMRC guidance for employers and employees does not seem to show that employers should be paying employees their 80% wages whilst the employer is waiting for the grant claim money to come through. What should employees do if they're not being paid while they're on furlough?
Yeah, I mean, that I think I alluded to certain wording. I think there's one particular sentence where it seems to suggest that an employer can wait for the grant to come. I'm not sure that that's the intention behind that particular clause. I think it's in particular. I think it's really directed towards the point that employers can't take a cut from the money that they get from the revenue. But I entirely accept that. In terms, it is ambiguous. It is ambiguous. There are other sections where it seems to suggest that employers should be paying this amount now, and your question effectively kind of reinforces that, because the whole policy behind this is to keep people solvent, to keep individuals solvent. You know, arguably, you could say the government has been less effective in its measures to try and keep businesses solvent. But it is to keep the money flowing. So I think it's very difficult to believe that the government's intention was that, as a general rule, employers shouldn't be paying people in this time. And in my experience, the vast majority of employers that we're dealing with are doing that as best they can. So I don't necessarily accept the assumption behind the question, though I think, as I've explained since the question was asked, I think in practice the Revenue and Customs might take a sympathetic approach. But in terms of the assumption that there are millions of employees who haven't been paid because they've been on furlough, I think to a certain extent that highlights the fact that that wasn't the intention. Although I agree that the government does need to do something for those organisations who, for one reason or another, can't at the moment afford to pay the 80%.
Thanks, Andrew. Couple of questions on sick pay. So this is from Anne Ormiston. Could you please advise how to approach the average calculation for an employee who has had an extended period of sickness payment within the previous year? Should this period be excluded from the average earnings?
Over to Andy.
Sure. Well, and I think this is one of the areas where what we talk about average earnings or regular wage differs between looking at something like holiday and looking at something which is potentially being reclaimed from government under the job retention scheme. So normally the provision would be that for holiday, it's time that is not worked. So if you're calculating a bank holiday payment, for example, you would not include full weeks where an individual is off sick because they are not working. Likewise, you don't include furlough. With the position under the job retention scheme, if it's looking at calculating what a regular wage is under there, then the guidance currently states that it is the higher of either a 12-month average in the pay year, in the tax year for 2019-20, or the same month in the previous tax year. I can see no reason why that wouldn't take into account periods of sickness absence in the same way that sickness pay is still wages. It is still considered part of a wage and can still be taxed in the normal way. I don't know if you would have any differing thoughts on that, Andrew?
No, it seems to make perfect sense. I mean, one of the life isn't easy. Life's complicated. So we've effectively now got two systems which are supposed to be average earnings systems, but they calculate average earnings differently. So we just have to manage our way around that.
Okay, thanks. Another related question. This is from David Alsop. If an employee has already been furloughed, then gets sick, do they revert to sick pay or would they stay on furlough?
That's it's an interesting one because it's one that we've discussed previously, and again, the guidance isn't clear. Now, I can imagine what people would likely do in practice and perhaps what the intention of the scheme was. And ultimately, the guidance that the government put out is very clear around people being able to claim statutory sick pay from day one for those that are either ill themselves or for those that are self-isolating for various reasons we discussed before. If you have an individual who has been furloughed, is not at work, I would imagine in practice it's very unlikely that employers would be notified if that person was to then become ill because they're not working, and it may not be a situation where an employer is checking in with furloughed employees every day. And there may be a financial advantage to the individual not to tell their employer in that circumstance. Now, I'm not saying that that is correct or should be done, but I can imagine that's probably likely. Other than that, I would say that and here's part of the difficulty that might arise, that if an individual is on sickness absence, government guidance again is clear that the individual is then not furloughed, is not under that furlough period. So you could have the strange position where somebody was honest and said in that third week of a furlough period they have become sick and they notify in a normal way. That may mean that then the whole furlough period is not something that could be claimed for, which is a little bit bizarre and certainly not the intention of the scheme. But it's not one that is covered explicitly in the guidance, unfortunately.
Okay, thanks, Andy. A few questions now on to holiday pay. This is from Bill Wright. It was by email. For those weekly paid operatives that have been furloughed, do we pay statutory holiday pay for Good Friday and Easter Monday, thus paying furlough for the balance of 4 days each week?
I can answer that. Yes, if effectively that's what's just been described. Importantly, of course, and this is an important point which nobody's addressed at the moment, you can still, even though it's a holiday day, they are still at the same time on furlough. So that proportion of the holiday pay that equates to the furlough pay, if you like, can of course be included in your claim to the Revenue and Customs when you're in a position to make that claim. I don't know whether you want to add anything on that, Andy, in terms of some of the technicalities, because I think Bill was probably using some JIB language there. But that, broadly speaking, I think is the correct answer.
Yeah, I'd agree. As you say, it is an important point that guidance and certainly legal advice is that there appears to be no reason why a company would not be able to claim at least the 80% for holiday days, be it bank holidays or general annual leave. They would obviously be required to top up the rest of that normal earnings level. But yeah, very, very important to cover. Other than that, it would appear that for the remainder of the weeks, that somebody would be effectively furloughed for 4 days, and therefore 80% of those 4 days would apply, and then there would be 1 day which was paid at the normal earnings level. That would seem to make sense, and certainly it is the way that ACAS, I think, seemed to envisage it. They've explicitly referenced bank holidays as being permissible in terms of those furlough minimum 3 weeks that apply. And again, when the scheme was developed, the government was obviously aware that the Easter weekend was coming up, and the scheme runs to the end of May, so that covers 4 bank holidays. So it does seem to make sense that was part of consideration.
Okay, thanks both. I think that broadly covers the other questions on that topic as well. So we'll just move on back on to specifics about furloughing. This is from Brad Nicholson. Do you need to have a consultation with all employees when turning furlough on or off, or does the original agreement stand?
I'll answer from a JRB perspective. So the template letters that we've developed will cover that. So explicitly in there is reference to people that may be temporarily brought off furlough and then back on again. So it depends on what the wording is in that agreement, but the JRB template certainly covers that. I believe the ECA one does as well. But
yeah,
Andrew.
Well, if it doesn't, Andy, it will. Yes, I think as long as you encompass it in the original consultation, you make it clear that this is a possibility, that people will be switching, then you're covered. You don't have to repeat the exercise each time.
Okay, this is from Vicky Kokoran. Once the initial 3-week furlough period is done, do you have to do another 3-week period, or can it be done week by week?
Any period of furlough must be 3 weeks. So the flexibility comes with regard to the period of work. So yes, you could have 3 weeks on, 3 weeks off. 3 weeks furlough, 3 weeks work. You could have 3 weeks furlough, 1 week work. I guess in theory you could have 3 weeks furlough, 1 day work, and then 3 weeks furlough. That might be more difficult to manage from a payroll point of view. But the guidance is clear that whenever there is furlough, it must be for 3 weeks. So you're not able to go 3 weeks and then a pause and then a week of furlough and then another pause. Any week of furlough must be for 3 weeks. By the way, just on that, from a policy point of view, ECA, along with the rest of the Construction Leadership Council, are lobbying government to reduce the 3-week period to 2 weeks. Obviously, we'd like it to be even shorter in reality, given the greater flexibility that would provide, particularly for those who are operating sort of emergency and essential cover operations. But that at the moment is in the realm of lobbying. The law is the law at the moment, the rules are the rules, and the rules of the scheme at the moment are that any period of furlough must be 3 weeks.
Okay, thanks, Andrew. One final question. This is from Tim O'Connor. As a JIB member company, could I ask my employees to not take annual leave up to the 2-year period and ask them to work and be paid the holiday pay on top of their work pay?
So under the Working Time Coronavirus Amendment regulations, there is now the flexibility to carry over what the regulations go into as the Euro leave days, which is 20 days of leave per year. Under the JIB agreement, the bank holiday days are normally set. Those can be worked, and time off in lieu taken at a future date to be agreed. There'll be nothing to prevent those bank holiday days forming part of those 20 days that can be carried over. And also anything beyond the legal minimum in the UK can indeed have a carryover clause as well. There's nothing to prevent companies from having that in their contracts, but it will depend on what are in those contracts of employment.
Just to chip in, I was glad Andy picked up on that, because to be honest with you, I found that question quite difficult to unpick and understand exactly what was meant. So Tim, if Andy answered your question, fantastic. If not, then please, as a JIB member, you can ring Andy and discuss it. As if you're an ECA member as well, you can ring the helpline and work through the specifics of what you're talking about there. Because I read it and I thought it could mean one of two or three different things.
Okay, thanks both. Thanks everybody for tuning in today. As always, our information and guidance can be found at www.eca.co.uk/coronavirus. Our next webinar will be on Thursday. It will feature Andrew again, but the majority of the presentation will be from Rob Driscoll, our legal and business director, and both will be covering some of the latest announcements from government and reviewing the past couple of weeks and letting you know all the key things you need to take forward. Okay, thanks everyone. Stay safe.